भारत की शिक्षा पद्धति हम चेंज नहीं करेंगे तब तक हम लंबे समय तक हम शासन नहीं कर सकते, लेकिन वो कोडिफिकेशन पे जोर देते हैं कि कानून बनने चाहिए। तो आपने देखा होगा कि आईपीसी हमारे यहाँ उसी पीरियड में बना, हमारे यहाँ सीआरपीसी भी उसी पीरियड में बना, 1898 में, 1860 में हमारा आईपीसी बन गया। ऐसे हमारा इंडियन एविडेंस एक्ट भी बना। ये सब वही पीरियड है, 1857 के बाद का पीरियड है जहां अंग्रेजों ने कोडिफिकेशन शुरू किया। आप जो मेजर जिसको आप एनएक्सटी नाम अपने प्रोग्राम का दे रहे हो, नरेंद्र मोदी जी ने भी इस प्रोग्राम में ये कहते हुए कहा कि हम 20वीं सदी के जो कानून हैं उनसे हम 21वीं सदी की प्रॉब्लम को सॉल्व नहीं कर सकते। हमें 21वीं सदी में जो नागरिक रहते हैं उनको न्याय देना है, उनको गुड गवर्नेंस देना है, और कानून हमारे 20वीं सदी के होंगे तो हम न्याय नहीं कर पाएंगे हमारे नागरिकों के साथ, गुड गवर्नेंस नहीं दे पाएंगे, हम डेवलपमेंट नहीं कर पाएंगे, हम उनका ईज ऑफ लिविंग नहीं दे पाएंगे। तो उन्होंने जो अंग्रेजों के जमाने में बने हुए कानून थे, आईपीसी, सीआरपीसी, इंडियन एविडेंस एक्ट, उनको बदला। और खाली उनको ही नहीं बदला, 1633 ऐसे कानून थे जिनकी आवश्यकता नहीं थी, उनको भी समाप्त किया। और मैं इस विषय पे ये कहना चाहता हूं कि अंग्रेजों को भारतीय नागरिकों को दंड देना था, इसलिए वो दंड संहिता लेके आए। नरेंद्र मोदी जी को भारतीय नागरिकों को न्याय देना है, इसलिए वो न्याय संहिता लेके आए। ये चेंज है, यही फर्क है।
It's been a revolution, ladies and gentlemen. So the entire penal code, the legislative code in terms of the application to criminal laws have all been changed in the past 2 years. They've all been modernized, enhanced. It's called the Bharatiya Nyaya Samiti. Sir, 660 crore, that's just under 7 billion pages. 660 crore pages of court procedures, court documents digitize किए गए हैं। ये इसको सर्च करने में, रिसर्च करने में, इससे क्या सहूलियत मिलेगी अब आगे पीढ़ियों को?
देखिए, अब कोई फैसला कभी कलकत्ता हाई कोर्ट में हुआ, कभी इलाहाबाद हाई कोर्ट में हुआ, अब वो उसका रिसर्च पेपर कहीं स्टोर में पड़ा है, उसको कुछ चूहे भी खा गए, कुछ साई भी फैल गई, तो वो जो रिसर्च करने वाला है या जो हमारा एडवोकेट है, वो उस फैसले में जज ने क्या लिखा, क्या आर्गुमेंट हुए, वो देख नहीं पाएगा ढंग से। इसलिए हमने डिजिटलाइजेशन के काम को बड़े पैमाने पर हाथ में लिया। और जैसे आपने कहा कि आने वाले समय में अगर कोई आदमी, जब से हमारा यहाँ कोर्ट सिस्टम शुरू हुआ है, इवन हम पहले से भी हमारे यहाँ जो हमारे भारत में ग्रामीण क्षेत्रों में जो पंच व्यवस्था थी, उनका भी कोई ताम्र पत्र है तो हम उसको भी डिजिटलाइज कर रहे हैं। कारण क्या है कि भारतीय न्याय व्यवस्था उस समय भी बहुत अच्छी स्थिति में थी, ऐसी बात नहीं है। जब हम स्वतंत्र नहीं रहे, परतंत्र हो गए, तो हमारे पर दूसरी एक न्याय व्यवस्था थोप दी गई। तो हमारी जो न्याय व्यवस्था थी, जिसको हमने पंच परमेश्वर की न्याय व्यवस्था की, वो हमारे से लुप्त होती गई। तो हमने मैन्युस्क्रिप्ट्स के माध्यम से भी उनको ढूंढा और उन सब का हम डिजिटलाइजेशन करा रहे हैं, जिनका लीगल इंपॉर्टेंस है। ये आने वाले समय में ये बहुत बड़ा क्रांतिकारी कदम है न्याय के क्षेत्र में।
7 billion pages of court records from all over the country. Sir, ease of living की मैं बात कर रहा था, प्रधानमंत्री भी इसकी चर्चा करते हैं, क्योंकि नागरिक के लिए, सिटीजन के लिए, that's what matters. जब हम स्कूल में थे, कॉलेज में थे, कुछ एप्लीकेशन फाइल करने के लिए या कॉलेज में एडमिशन करने के लिए सब कुछ गजेटेड ऑफिसर से अटेस्ट कराना पड़ता था। अब सेल्फ अटेस्टेशन है, ऑनलाइन फाइलिंग है। सो ईज ऑफ लिविंग से जो कानून घट रहे हैं, डिजिटलाइजेशन हो रही है, और नागरिक में जो हम कॉन्फिडेंस दिखा रहे हैं कि आप सच बोलते हो एंड वी ट्रस्ट यू, इससे ईज ऑफ लिविंग की क्या बढ़ोतरी हो रही है?
देखिए, हम अगर लीगल फील्ड में बात करें तो हमारे यहाँ ई कोर्ट प्रोजेक्ट फेज 1, फेज 2, फेज 3, अभी 3 में हम चल रहे हैं। एक मैं लिटिगेंट के नाते बात करूं कि अगर मेरा केस चल रहा है और मेरी अगली पेशी क्या है, तो इस प्रोजेक्ट से पहले मैं या तो मैं वकील साहब को पूछता या मैं रीडर को पूछता मेरी नेक्स्ट पेशी क्या है। लेकिन नरेंद्र मोदी जी ने नागरिकों को सुविधा देने के लिए, लीगल क्षेत्र की बात कर रहा हूं, कियोस्क बनाए, सेवा केंद्र बनाए, और वहां जाकर के उस मशीन में टच स्क्रीन के माध्यम से वो अपना केस नंबर डालेगा, तुरंत ही आ जाएगा कि इस कोर्ट में आपका मुकदमा चल रहा है और उसकी नेक्स्ट हियरिंग डेट ये है। यही ईज ऑफ लिविंग हम हर क्षेत्र में लीगल फील्ड में उपलब्ध करा रहे हैं।
अर्जुन राम मेघवाल जी, थोड़ा एक टेक्निकल सवाल पूछूंगा, क्योंकि आप इस पे चर्चा बहुत करते हैं, दिस कॉन्सेप्ट के लिटिगेशन कम हो, ऑल्टरनेटिव डिस्प्यूट रिड्रेसल मैकेनिज्म्स की बढ़ोतरी हो, इस पे क्या भारत में काम चल रहा है?
देखिए, एडीआर, अल्टरनेट डिस्प्यूट रेजोल्यूशन मैकेनिज्म, एक कंसेप्ट जो था उसको नरेंद्र मोदी जी के पीरियड में बहुत काम हुआ है। हमने मीडिएशन को बढ़ाया है, हमने कंसिलिएशन को बढ़ाया है, और हमने आर्बिट्रेशन को बढ़ाया है। और इसके द्वारा हम चाहते हैं, और प्री लिटिगेशन सिस्टम को भी हमने ठीक किया है, कॉमर्शियल कोर्ट हमने मजबूत किए हैं। इससे जो पेंडिंग मुकदमे हैं वो निश्चित रूप से कम होंगे। ये हमारे, और उसके साथ साथ जो हमारा ई कोर्ट प्रोजेक्ट 3 है, उसके माध्यम से सपोज करो कई बार दिल्ली में क्या होता है, एडवोकेट ट्रैफिक में फंस गए और कोर्ट नहीं पहुंच पाए, उनका केस सुनवाई के लिए आ गया, तो उस समय तो वो अपनी आर्ग्यूमेंट ही नहीं कर पाते थे, पहले एक टाइम था। अब हमने वीडियो कॉन्फ्रेंस के माध्यम से भी आप अपने केस को आर्ग्यू कर सकते हो, ये सुविधा दी। हमने ई फाइलिंग की सुविधा दी। ये जो नए एक्ट जिनको आपने कहा कि आईपीसी की जगह हम भारतीय न्याय संहिता लेके आए, और सीआरपीसी की जगह हम नागरिक सुरक्षा संहिता लेके आए, इंडियन एविडेंस की जगह हम भारतीय साक्ष्य अधिनियम लेके आए। इनमें हमने ये प्रावधान किया कि आप घर बैठे भी ई फाइल कर सकते हो, और अगर आप कहीं रास्ते में हो और कोर्ट नहीं पहुंच पा रहे हो, तो आप अपना कंप्यूटर खोलिए, आप लैपटॉप खोलिए, और कोर्ट से रिक्वेस्ट करिए कि मैं वीडियो कॉन्फ्रेंस के माध्यम से मेरे केस को आर्ग्यू कर सकता हूं। ये ईज ऑफ लिविंग है इन लीगल फील्ड में।
सर, एडीआर के साथ साथ आर्बिट्रेशन का भी मुद्दा होता है। नो, ये थोड़ा तकनीकी सवाल है, लेकिन कभी कभी आर्बिट्रेशन भारत से बाहर चले जाता है। लोग कहते हैं सिंगापुर जाओ, दूर जाओ। भारत ये आर्बिट्रेशन का हेडक्वार्टर कैसे बन सकता है?
देखिए, ये आपने बहुत सही सवाल उठाया। 4 ऐसे आर्बिट्रेशन सेंटर हैं जिनकी आप क्रेडिट कहिए कि पूरे इंटरनेशनल मार्केट में काफ़ी अच्छी बनी हुई है। उसमें आपका सिंगापुर आर्बिट्रेशन का सेंटर है, इंटरनेशनल सेंटर, आपका दुबई का है, हांगकांग का है, लंदन का है, और नरेंद्र मोदी जी की ये इच्छा भी है कि हम आर्बिट्रेशन हब बनाएंगे भारत को, क्योंकि उसमें हमने केसेस देखे हैं कि काफ़ी केसेस होते हैं जो भारत से संबंधित ही होते हैं। एडवोकेट भी कई बार भारत के होते हैं, कई बार 1-2 बार तो ऐसा समझ में आया कि जज भी भारत के हैं। तो भारत आर्बिट्रेशन का हब बने, इसके लिए नरेंद्र मोदी जी आर्बिट्रेशन एक्ट में भी संशोधन किया, मीडिएशन एक्ट में भी संशोधन किया, और एक और संशोधन आर्बिट्रेशन एक्ट में प्रस्तावित है। और मुझे पूरा विश्वास है कि एडीआर को, अल्टरनेट डिस्प्यूट रेजोल्यूशन मैकेनिज्म को नरेंद्र मोदी जी जिस तरह से जोर दे रहे हैं, आने वाले समय में भारत भी आर्बिट्रेशन का एक मजबूत हब बन करके उभरेगा।
ये बहुत खुशी की खबर है दैट इसको हम फुल डायमेंशन, फुल 360 से देख रहे हैं। मेघवाल जी, एआई के ज़माने में हाल ही में भारत में अभी एआई इम्पैक्ट समिट हुआ है। विश्व भर के 40 हेड्स ऑफ गवर्नमेंट थे यहाँ पर। सारी एआई कंपनीज के सारे फाउंडर्स सब यहाँ पर आए थे। एआई की गवर्नेंस की लीगल फ्रेमवर्क में भारत क्या मार्गदर्शन दे सकता है?
देखिए, जो अपने एआई ग्लोबल समिट की बात की जो भारत में हुई, ये इंडस्ट्री 4.0 का एक कंपोनेंट है। हम अगर थोड़ा पीछे चलें तो जब इस दुनिया में स्टीम के इंजन का आविष्कार हुआ तो उसको इंडस्ट्री 1.0 बोला, और जब इस दुनिया में बिजली का आविष्कार हुआ, पावर का, तो इसको इंडस्ट्री 2.0 बोला, और जब इस दुनिया ने कंप्यूटर का आविष्कार किया, आईसीटी, इंफॉर्मेशन टेक्नोलॉजी, तो उसको इंडस्ट्री 3.0 बोला। लेकिन अब जब हम इस युग में प्रवेश कर गए हैं, इंडस्ट्री 4.0, तो उसके मेजर कंपोनेंट आर्टिफिशियल इंटेलिजेंस है, 3D प्रिंटिंग है, रोबोटिक टेक्नोलॉजी है, आईओटी है, मशीन लर्निंग है, ब्लॉकचेन टेक्नोलॉजी है, ये सब उसके पार्ट है और हम इसके बिना रह भी नहीं सकते। इंडस्ट्री 1.0 आया था, तब भी कुछ लोगों ने विरोध किया कि नाव चलाने वाले क्या करेंगे। इंडस्ट्री 2.0 आया, तब लोगों ने कहा लालटेन बनाने वाले क्या करेंगे, पेट्रोमैक्स बनाने वाले क्या करेंगे। और इंडस्ट्री 3.0 आया, तब भी लोगों ने कहा कि बहुत से लोग बेरोजगार हो जाएंगे, लेकिन कोई नहीं रुका। इंडस्ट्री 1.0 भी आया, 2.0 भी आया, 3.0 भी आया और नागरिकों के जीवन को आसान करते गए और रोजगार के अवसर भी बढ़ते गए, रोजगार के स्वरूप भी बदलते गए। तो अभी जो ग्लोबल समिट हुई थी आर्टिफिशियल इंटेलिजेंस को लेकर के भारत में, उसमें निचोड़ ये निकला कि माना ये हमारे लिए चैलेंज है आर्टिफिशियल इंटेलिजेंस, इसमें साइबर केसेस बढ़ेंगे, क्रॉस बॉर्डर टेररिज्म के कुछ केसेस बढ़ेंगे, चैलेंज है, लेकिन इस चैलेंज को हमें अवसर में बदलना है। इसलिए इस समिट में ही तय हुआ कि रोजगार के अवसर कम नहीं होंगे, एआई टेक्नोलॉजी आने के बाद रोजगार का स्वरूप बदल जाएगा, जिसके लिए हम तैयार हैं, जिसके लिए भारत तैयार है। और नरेंद्र मोदी जी अपने गवर्नेंस में इसकी प्राथमिकता देते हैं कि इसको हमें भारत को इसके लिए तैयार रखना है। और आपकी आज की कॉन्फ्रेंस, आपका सेमिनार भी इसी को ही इंगित कर रहा है।
मेघवाल जी, इसी मामले पे और इसी मुद्दे पे आर्टिफिशियल इंटेलिजेंस पे इसकी लाइन कहाँ है, हद कहाँ है कि आर्टिफिशियल इंटेलिजेंस, क्योंकि आजकल लॉ स्टूडेंट्स इस्तेमाल कर रहे हैं उसे ऐसे रिसर्च करने के लिए। कुछ लोग कह रहे हैं रिसर्च करना एआई से अच्छा है, सही है, लेकिन एआई आपका पेपर लिख रहा है वो गलत है। इन द लीगल फ्रेटर्निटी विद इन द प्रैक्टिस ऑफ लॉ लाइन क्या है? क्योंकि कुछ लोग तो बोल रहे हैं कि ऐसा जमाना आएगा कि भी कंप्यूटर ही जजमेंट भी पास कर रहा है।
कुछ देशों में इस तरह के प्रयास हो भी रहे हैं, लेकिन इसके बावजूद भी हम कहते हैं कि टेक्नोलॉजी अपनी जगह है और मनुष्य का दिमाग अपनी जगह है। ह्यूमन बीइंग का स्थान कोई टेक्नोलॉजी नहीं ले सकती।
ऑन दैट वेरी फिलोसॉफिकल नोट, अर्जुन राम मेघवाल जी, हमारे साथ इस मंच पे जुड़ने के लिए बहुत बहुत धन्यवाद।
थैंक यू।
आपने बहुत क्लैरिटी दी है कि क्या लीगल रिफॉर्म की स्पेस पे यहाँ पर भारत में चल रहा है। बहुत बहुत धन्यवाद। लेट्स हैव अ राउंड ऑफ अप्लॉज लेडीज एंड जेंटलमैन।
थैंक यू।
That, of course, was our special segment on Next in Law. We will return to it shortly with another panel discussion as well. But for now, I want to quickly turn our focus to Next in Finance. Yes, of course, at the end of the day, it is very important to have a robust economy and equitable finances. But what is going to be the impact of artificial intelligence on this sector? Well, for this segment, as part of Next in Finance, and to talk about the theme of AI and finance, we have a very erudite panel that is with us already in our Bharat Mandapam venue, which is, of course, hosting the NXT 2026. I want to quickly invite on stage Ameya Prabhu, MD NAFA Capital. Ameya, welcome. Also with us is Amar Shah, MD and Head of Global Markets, NFPR for Bank of America. Amar Shah, welcome as well. Mr. Bipin Babu also joins us now. Founder, Grow QR AI. Could we please have you on stage as well, Bipin? And this panel is going to be moderated by Dr. Namit Choksi, CEO of Tend Health. So, Dr. Namit, you have to put on your moderator hat for this session. Thanks for doing the honors, and over to you.
Good afternoon, everyone. Such a pleasure to be here, and we have a August gathering and a great, panel discussion here. The focus of this panel will really focus on what's next in finance. We have a regulator here, we have a family office allocator here, and we have someone who works at the intersection of AI in a lot of things in finance. So, going to be an interesting afternoon. Let me actually, start with Amay. India is often described as the next major growth story. And as an investor who operates in India and also outside, where do you think the most compelling opportunities will lie in the next 5 years and in the next decade?
Thank you, Namit, and thank you for having me here. I'd like to thank the entire NXT team and Kartikeya ji to having invited me here on this august platform. I would disagree when people say that India is the next growth story, because India is the current growth story. It is not only today's growth story, it was also yesterday's growth story, it is tomorrow's growth story, and it's also day after tomorrow's growth story. I think today, if you see, I always tell people that India is not an emerging market, it is a re-emerging market. Because if you look at history over the last 2,000 years, and the Honorable Ambassador Bartoli spoke about the relationship between India and Italy and of Rome and India in those days. India has always been a global economic powerhouse. We have always been up to 20 to 25% of global GDP. Of course, today we are 2.2% of global GDP, but in the last few years, thanks to our government, we have massively expanded. So India is today's growth story, India is tomorrow's growth story, and India is a growth story which will remain, at least for the working lives of all of us in the audience who are here. I see a lot of young students here who are listening to us, and I think for all of your lifetime, your country, your economy, and your passport will become increasingly more powerful, because ultimately, when the economy becomes powerful, your passport becomes powerful. And I think that is very true of India. Secondly, you asked me which are the sectors which will do well. India is like an ocean. And when the tide goes up, every ship in the ocean goes up. So similarly, today, if you ask me, every sector, if you ask me, I cannot pinpoint one sector. You are from the life sciences and pharmaceutical sector. Yesterday, we had a great panel on that with Dr. Kakkad, yourself, amongst others. Life sciences is one space. Agriculture is another space. Today, due to the geopolitical instability, we are all talking about defense. Defense is another space. We have the second largest standing army in the world, one of the largest air forces and navies in the world. Defense is another space. Then you have industrials, you have steel, you have AI. So I think when the tide goes up, and India is a rising tide, the entire economy will, I would say, in a secular fashion grow. And of course, at the end of the day, every device, the human body needs water, the economy needs finance. Finance is the lifeblood of water, and this panel being relevant on that. So the finance industry, not only does it have to keep pace with the growth of the economy, it has to stay one step ahead, so as to not only meet the challenges of today, but also the challenges of tomorrow and day after.
Very well put. And I really echo that, right? Like, we have a lot of these, that India's time is right now. And in my head, I was like, India's time was there always, and it will continue being our time. Let me switch gears a little bit. We have Amar joining us from New York, and he's a regulator. And, as someone in finance, we have a love-hate relationship with regulators. So, onto that, since 2008 financial crisis, the global financial system has seen a massive expansion, really, in terms of regulation. Now, someone who sits, at that intersection of regulation and finance, has the regulatory architecture actually made markets safer, or has it made it significantly more complex and increased the cost of doing business?
Very good question, Namit. First of all, pleasure to be here. And again, I thank you, NXT Conclave, to invite me all the way from New York. It's been a pleasure here, hearing all the guests. Coming to the regulatory framework, right? I think the financial crisis, and I was in the heart of the financial industry back in New York when all of this fell down. Very bad time back in the day. Post 2008, I think the market definitely has become safer. The regulatory architecture put together, not only by the US, but by the global regulators and the central banks around the world, have really made the market very, very safe for the investors and also for the financial community. Things like increased capital requirements, increased regulatory liquidity standards, adding stress testing to global financially important institutions, building regimes like resolution and recovery planning, all of that has significantly improved a lot of regulatory burden for the financial institutions. So you're right, it is kind of counterproductive to deploying more capital, using more capital, but at the same time, it has risen the investor confidence significantly. An average investor has more confidence in the market post 2008 than what it was. It is evident by the market volumes, the growth of new products and sectors across the world. Cross-border movement of capital has increased significantly because of that. Along with that, there has been a lot of expansion on transparency. The reason why the 2008 crisis came into light is a lot of people didn't understand complex financial products, right? So derivatives market is very opaque to a lot of people. So a lot of transaction reporting frameworks have been established globally, and that has resulted in significant improvement in transparency for the entire community. It does add a little bit of inefficiency if you think about it, but in the theme of AI, which we're going to talk about, I think this complexity that has been created will be oversimplified by the newer tools available, both to the investors as well as the financial community, that can decipher this information and can actually make better decisions using the information that the regulators provide. I think it's a win-win for both the community, the investors, as well as the promoters, if you will, for the company.
I see. That's very helpful, right? And I mean, to protect public capital has become so increasingly important because it's all your hard-earned money, you know, out in the markets. And I echo that. You mentioned AI, which I think is a perfect gateway to question for Bipin. You know, AI is increasingly being used now for, you know, research, trading, portfolio construction. Do you believe AI will fundamentally outperform human investors, or will the best investors be those who combine AI with what they do day to day?
Thanks, Ramit, you know, it's a great honor being on this stage, and thanks to our friend and honorable MP Kartikeya Sharma. To answer your question, Namit, I believe that for traders, for investors, AI will always remain to be a tool that actually harnesses their strength much more. And I firmly believe that whatever SLM models we build, you know, whatever AI diffusion we do, be it in finance industry, be it in any other industry for that matter, humans would remain, should remain, you know, at a level where they use this tool and make their decision-making power much better. And anything around analysis or anything around processes, they should let the model do. They should let the AI tool do. And it actually makes you more powerful. It's like, you know, Arjun getting an avatar, you know, getting a Vardhan to do better in the battle. So that's what I see, you know, AI as. And I think, you know, the winning companies or winning enterprises or winning countries would be the one which actually ensure three things. One is definitely infrastructure, which, you know, a lot of us are doing, and thanks to the government of India. We're solving the infrastructure problem, be it chips, be it compute power. Second is going to be talent. That is the winning element in this entire game. And last is access. So the more access we give to the first two, the more possibility of winning becomes for us. So I think we as a country, we as startups or enterprises or larger organizations, I think these three things have to be in place, and that will, you know, keep the human element also alive.
So, you know, I'm a physician turned investor, and so I think what I'm hearing is AI will not, should not completely replace that human heart that we bring to investing, but it'll always be used to augment all that we do, very similar to healthcare. On that note, you know, Amay, you're someone that I've also looked up to greatly and, you know, learned a lot of my investing principles from, right? For those young investors out watching us and in the audience, one question that I really have for you is, what separates great investors from average ones? Experience, you know, access to deals, speed of decision making, or simply temperament?
I'd also add one more thing to that is luck. But, no, I think it's a mix of all. I think, you know, I think ultimately it's time that teaches you who's a great investor, who's not. Again, what I mean by that is, sometimes, we have a public markets fund. And I think public markets is a very unforgiving place for those who don't manage to, ride the test of time. So sometimes, as we say Hindi में जब market में तेजी होती है, तो सब लोग बाजार में पैसा बनाते हैं. So when there is a rising tide in the market, everyone makes money. But you need to see a few cycles of a market to differentiate who's a great investor and who's actually a average investor. And I think the difference also comes in not just picking the right companies, be it in public or private markets, or if you look at debt, investment is a large spectrum and horizon. We have someone very senior from BOFA here, they've seen the world, but you have infra investing, you have project finance investing. But I think ultimately it's time which teaches you, number one. Number two, temperament, knowing when to hold, knowing when to sell. I think knowing when to buy, I think that's also something which comes with experience, as with everything else. And I think if you ask me in the list of things, I think ability and knowledge, I would say, maybe comes third. Because I think today, if you see, when our parents were young, access to information was a very big differentiator. Because there's a lot of asymmetric information in the market. By the time we got into, say, career, by the time we got into colleges, you had the internet. So access to information became a less of a differentiator. Access to knowledge was the big differentiator. Today with AI, even access to knowledge has now stopped becoming a differentiator, because literally if I want, before this question and my next question, if I anticipate what you're saying now, I'll have all the best knowledge and I can sound like an expert, even though I know nothing about it. If I can just look at my, Gemini or my Chat GPT or Anthropic, or on Claude. So point is, access to knowledge also is becoming, so what really differentiates is your temperament, is your ability to use that knowledge, and over time, which teaches you, as they say, it separates the boys from the men. And I think that's what essentially shows, or the girls from the women, because that's what essentially shows, the thing. So I think ultimately you have to give time for anything.
I see. No, very well said. And investing is, I always think of it as an art more than science, right? Like there is, technical knowledge can only get you to a certain place, and you got to mix that with your emotions, your temperament, your experiences, your networks. Talking about temperament and, thinking about where we are at as India, Amar, one question for you, as someone who sits at a more global scale, if India wants to attract deeper pools of, institutional capital from, let's say, pension funds, sovereign wealth funds, corporate banks, what do you think are the structural reforms that would matter the most, right? Would it be transparency, enforcement, reporting standards? If you can kind of walk us through that and maybe kind of prioritize that in an order from your experience.
Great question and a great segue. And I want to echo some of the enthusiasm, right? I mean, this has been an India great story, India next. And sitting at where I sit in BOFA around regulatory compliance, it's very interesting to see some commonalities, right? So you gave me 3 themes saying, okay, transparency, enforcement, and reporting standards. I would say predominantly, definitely all of them are important, but I think the enforcement is more important. If I was a global player, I would definitely respect a lot of good laws being there in the financial market, so we know the structure is in place. But if enforcing the law and making sure it's a level playing field, both for a global institution plus a local market player, gives me more confidence to come in the market. I have an equal chance to actually succeed and survive. And builds more trust on the local market and the local regulatory body. Reporting standards, absolutely, there is going to be a lot of divergence, and it's usually a divergent pool of resources that work towards that. Every country has lawmakers and policymakers. They have the best of the intentions to create the best, transparent reporting standards for their jurisdiction, their country. But having some level of level playing field, be it accounting standards, be it the standards on which you report capital liquidity, those things really help significantly for a foreign institution to come in and say, look, how do I gauge a Indian market to put my capital in versus some other country? Because at the end of the day, you want to benchmark yourself against a global level playing field, right? Because return for my investors and my shareholders for a global institution, how do I make a choice? and the choice is very important, right? So if I were to summarize, right, I mean, I would still say enforcement with good laws and consistent reporting standards. It's a mix of everything, but in that order will really make India much more attractive, in the coming days. It is already very attractive, but it'll make it more attractive for the future inflows, given all the things that's going around the world, right? Yeah.
Well, so what I'm hearing is a lot of kind of, reporting standards, enforcement, etc., help with de-risking, and that's kind of essential for us to be a trusted partner in that order. And I do think that the government is doing a lot of work in that direction under, Honorable PM's guidance and vision. Switching gears a little bit, Bibin, back to you. We talk about risk, and everyone's really excited about artificial intelligence and, all the good things that kind of come along with it. And as someone who's, incubated and grown so many beautiful companies in this space, one question I have for you is, AI systems are only as good as the data they train on, right? As someone who runs a bunch of AI companies, especially looking at this finance panel, what do you think are the biggest risks of relying on AI-driven models in financial decision making?
I'm quite an optimistic, guy in terms of technology. So I rather see this as de-risk, for the entire industry and anybody, who uses it, be it larger organizations, larger capital ones, or startups, or individuals for that matter. Because if you look probably 10 years back or 5 years back, a small trading firm or a small investment firm would refrain from doing investments into large cap things or large investments because they don't have that kind of a capability or that 50-member analyst team or anything to take a decision. And on top of it, then comes the compliance which they have to fulfill once they do that, right? And then there is risk.
Be careful, Amar is watching you.
So I think what AI models have done well, and so what I was mentioning is it's a level playing field for everybody. So in fact, I met a trader yesterday. He said, today because of AI, I'm as good as the largest trading firms in the world because I have all the analysis that needs to be available. And best is that there are also companies that are building SLM models, which are region specific. So that's actually a problem for the larger companies. You have tougher competition now. So so somebody sitting in Pune, or maybe Kozhikode or Kochi, has equal information and access, of what you guys have or larger firms have. But before I close, I wanted to have this one bunch of kids who came and met me, and they said they were worried about jobs thing. So I'll just maybe with your permission, right? So this bunch of kids are asking that jobs are being destroyed, jobs are being destroyed. So one thing which we all should realize is that whenever there has been a technological revolution, there has always been disruption of jobs. So, this is to, give you more confidence, guys, that it is only disruption, but I'll also be very realistic that, yes, there will be a lot of jobs that will be destroyed. All jobs will be disrupted, and some new jobs will be created. So the opportunity is there, and since I see a lot of students, I think all that we need to do is to ensure that we navigate our career and navigate our skills in the right manner. Technology is not the challenge, navigation is. So if I'm able to navigate that, you guys are through. I'm sorry to deviate.
No.
But 7, 8 of them came and I said, I should address
Great
this.
question, and I think Amay wanted to add to that.
I wanted to add one quick point to that. We have my father was a chartered accountant back in the day, and he had an office in Canara Bank building in Ballard Estate in Mumbai. And I remember as a kid, when I was 6, 7 years old, early 90s, when I used to go, every time there used to be a bank strike against computerization. कि कंप्यूटराइजेशन नहीं चाहिए बैंकिंग इंडस्ट्री में, जॉब्स जाने वाले हैं. अब ऑलवेज होता था एंटी कंप्यूटराइजेशन, एंटी आईटी. टुडे कैन यू इमेजिन द बैंकिंग सेक्टर विदाउट कंप्यूटर्स? They said the computers will kill our jobs. Today computers and IT created thousands of more jobs, I would say millions of more jobs, tens of millions of more jobs. I can guarantee you, similarly there was to be hartal against cars back in the day because horse carriage industry was against it. What will happen to the horses? What will happen to the horse breeders? What will happen to the guys cleaning the streets of the horse, this thing, feces? But that also car industry created millions of more jobs. I can guarantee you today we have an insecurity ki jobs kidhar se aayenge. We'll have so many jobs in AI because see, the AI itself tells you it's artificial, boss. We need someone natural to manage that artificial intelligence by definition. So don't worry.
And I mean, even as a PE investor, I'm often jealous of those young AI engineers who come in and it's like, I want this package. And I look at them and I'm like, oh my God, when I was your age, I probably had a package that was 1/10 this size and I was still happy. So definitely, yes, not. AJ, you have some comments?
So the last thing, and I echo to everything what they said, right? What I would say to the younger generation is like, no matter how much AI comes in, what we typically use in our company is we always need a human in the loop. And without a human, the machine can only do so much. So you are the human in the loop. The job you do today might change, but that's evolution. And let's be ready for it, right? So the same message, yeah.
Well, great message. My last question, as we kind of wrap up this panel, it could be two-word answer. As we think about future of investment, I want to ask each of you, what is the one investment trend today that you think is completely overhyped? I'll start with you.
AI, because it's overhyped. And despite all of that, there are other things as well, in life.
But I think every industry had a hype, right? But for me, I think it's the LLM models that has super hyped.
Okay, so you're also saying AI.
I'll go with the trend.
Well, gentlemen, it was such a pleasure being with all of you this afternoon. Thank you again for your time, and thank you, audience, for being such a wonderful audience. Well, let's get together for a picture.
Thank you very much for your time, gentlemen. And now we move to, of course, our next segment and our session on the future of the blue-collar economy. This is part of the Next in Trade session and segment. For this special address on the future of the blue-collar economy, I would like to call on stage Member of House of Commons, United Kingdom, Honourable Dan Carden, Member of Parliament. Dan Carden, could we please have you on stage for your address? Welcome to NXT 2026. Let's keep the applause going for the Member of Parliament from the United Kingdom.
Conference, it's a real honor to be here, and I'm delighted to see so many young people here, and I hope you're enjoying the contribution from all of the panelists that we've heard from. And can I also say thank you to the Honourable Kartikeya for his innovation in bringing this event to life. I'm a Labour politician from the United Kingdom. I'm going to give a political speech, and I hope you'll forgive me for that. And I want to tell you a little bit of a personal story, because my father worked on the docks in Liverpool, and I'm from a working class family. He was a shop steward, a union man, a man who believed in the dignity of work, that it was worth protecting even at personal cost. And my experience as a young boy was when my father was pushed out of work because of industrial action. He never stopped believing that work and the dignity of work had a place in his life and in the world. And I think about my father when I think about technology, and in particular artificial intelligence, and what it's going to do to our economy, your economy for the future. Not because I'm afraid of technology, I'm not. I think about him because I want to ask a question that's not being asked enough. But it's, what do we owe the people who built what we have today? And I want to answer the question by talking about two people that many of you in this room, I imagine, will not know. But I hope at the end of this, you'll know a little bit more. The first is a man called Ernest Bevan. He left school at the age of 10. He grew up in the countryside of Somerset in the United Kingdom with nothing. No money, no connections, no education. He built the Transport and General Workers Union into the most powerful labour union in British history. And he became Winston Churchill's Minister of Labour during the Second World War, putting the entire British economy on a war footing. And after the war, as Foreign Secretary, he helped design the world order, the international world order. He was one of the architects of NATO, and yet he had no formal education. And the second man is Clement Attlee. He led Britain's Labour government after 1945 in the Second World War. The country was exhausted, bombed and bankrupt, and every conventional political instinct said, recover slowly, manage decline, ask for sacrifice. But Attlee's government looked at the situation and chose a different path entirely. In 5 years, they created the National Health Service. They built over 1 million homes. They established a welfare state. And they did this not because it was popular or affordable in the narrow sense. They did it because they believed the purpose of government is to organise the resources of a nation in the service of its people. Bevan and Attlee were not optimists in the comfortable sense. They'd lived through world wars, the Great Depression, the hunger marches, grinding poverty, and early industrial Britain. They knew what it cost when societies failed working people, and they chose deliberately and at great political risk to build something that would outlast themselves. And I tell you that because I believe we are in that moment again. Artificial intelligence and the rapid onset of technology is not just another change. It is a revolution. It's the most profound transformation of the conditions of human work since the Industrial Revolution. The OECD estimates that 27% of jobs in wealthy nations are at risk of automation. The IMF puts 40% of jobs in play worldwide. The World Economic Forum projects a net global loss of 14 million jobs by 2027. These numbers are already arriving in specific, visible ways. Just outside of my constituency of Liverpool, a factory employed 400 workers 2 years ago. Today it employs 60. An AI scheduling system replaced the rest. Some of those 340 people are my constituents, and I know what happened to their families. But it's not only blue-collar workers. The junior lawyer who spent 3 years reading case files is being replaced by AI research. The accountancy graduate, the university leaver who studied to enter a profession is finding that the entry-level rung has been automated away before they could even stand on it. And there is another version of this story, the positive version, because a surgeon can use AI diagnostic tools to make her 10 times more effective. She can see twice as many patients, catch conditions she would have previously missed. The same technology, but a different outcome. The trade union movement that my father belonged to and that I belonged to believed in 3 principles: educate, organise, agitate. And I'm going to finish by touching on these 3 points as I think they apply today. In education, we're making a mistake in most of our school systems when we're not teaching the next generation how to use the tools that will define their working lives. AI literacy, not computer science for the elite, but practical, accessible training in how to work alongside AI is the single most important skill for the new economy. And it's not being taught at scale in the schools that serve working class communities. Before we talk about anything else, every government in this room should ask one question: does your Ministry of Education have a plan? And if the answer is no, it's time to find one. But education reform means something more specific than AI training. Britain spent 30 years telling every young person they should go to university. We built an economy of graduates while our manufacturing base was hollowed out. Our skilled trades went unstaffed. Our infrastructure crumbled for want of engineers. The electrician, the plumber, the machinist, the toolmaker, these were not the consolation prizes for those who failed to make it to university. They were the people who kept the country running. And here is what AI tells us about them today. A skilled tradesperson with AI tools becomes dramatically more productive. A trained engineer with AI design assistants can do in a day what they used to do in a week. These are the jobs that cannot be offshored, cannot be fully automated, and become more valuable as the AI transformation happens around them. It's not simply more education, but it's the right education for the economy we need to build. And secondly, organise. The data that powers AI was generated by ordinary citizens like every one of us. Every search, every purchase, every hospital visit, every financial transaction. That data today has huge commercial value, and it's currently captured almost entirely by a small number of technology companies. So we need a framework, data trusts, public data funds, mandatory royalty arrangements that ensure that the people who generate economic resource receive a share of its value. India has already shown what organised public digital infrastructure looks like. UPI, the payment system that now processes more transactions per day than Visa, was built on public infrastructure, owned by the Indian people, designed for inclusion rather than extraction. That is the model. That is what it means to organise around the AI economy, rather than simply be subject to it. And finally, agitate. No matter how much the economy changes, there must be a floor below which no worker falls, not just in income, but in security, in dignity, and the sense of being valued. That means stronger employment rights, not weaker ones. It means portable benefits that follow workers across jobs and platforms. And it means unions that can represent gig workers and platform workers, as well as employees. And it means governments that are willing to say plainly that the productivity gains from AI must be shared, not accumulated at the top, while the people who generated the underlying data receive nothing in return. So agitation, in the trade union sense, means refusing to accept that this is all inevitable. And I believe the way we respond to AI will determine whether our generation passes the test that our previous leaders met. In 1945, Attlee's government was asked, what do we owe to the people who won this war, who built this country, who gave everything? And the answer was the NHS, 1 million homes, a welfare state, a commitment that no one who works and contributes should be abandoned. It wasn't a modest answer. It was not a convenient answer, but it was the right one. And the AI economy is asking us the same question about the generations of today. What do we owe to the warehouse worker whose job has been automated, to the accountancy graduate who cannot find her entry-level role, to the young engineer in Bangalore, Lagos, or Liverpool who is brilliant and willing but cannot find work because the system has changed faster than the institutions that were supposed to protect them? Bevan and Attlee answered their version of this question with everything that they had. The question for every person in this room is, can we answer our question today? Because AI will not decide the future of work, politics will. The question is whether the politics of today is quite up to that moment. Thank you very much for listening. I appreciate your attention. Thank you.
Thanks indeed, Right Honourable Member of Parliament, of course, of the United Kingdom there, Dan Carden, who was speaking with us, of course, and was looking forward at the future of the blue-collar economy. We'll also be hearing from him in another special panel in just a bit. Okay, well, let's turn our attention back to our special segment, Next in Law, because we are now extremely humbled to be joined by a very special individual, a sitting judge, of course, of the Supreme Court of India, Honorable Justice J.K. Maheshwari. He is with us at NXT now, and I invite you on stage, sir, for your keynote address as part of our Next in Law segment on dispute resolution and the future of law. A round of applause for Justice Maheshwari.
Good evening, distinguished dignitaries, our guests from abroad, delegates, professionals, gracious ladies and gentlemen. It's a profound pleasure to be present in this august gathering, a hall filled with architects of our collective future, lawmakers, business leaders, academicians. Decision you make now will have lasting effect over decades to come. We meet today at a crucial inflection point in human history. As we speak, geopolitical tensions are simmering, economics are being stressed by their breaking points, markets are on a free fall, resulting in a commercial uncertainty and disputes. But perhaps most significantly, there is an increasing sentiment of institutional fatigue, a growing sense that our traditional mechanisms of justice are perhaps struggling to keep pace with velocity of modern conflict. We are witnessing a paradigm shift where the old command and control concept of law is being tested by a globalized world that moves much faster than a court calendar. In these circumstances, can we afford a stick to adversarial dispute resolution instead of embracing the era of problem solving? First, I will say evolution of disputes resolution. As we embark upon a discussion about dispute resolution and the future of law and the role of courts, arbitration, mediation, and technological advancement shaping the future of justice system globally, in order to understand dispute resolution, we must first define the problem. What exactly constitutes a dispute? Every dispute begins with a gap between the expectation and reality, a perceived injury. In the foundational wisdom of Indian scripture, we find Sanskrit principle that satyena rakshet dharma. Truth protects the law and or the dharma protects the truth. The Supreme Court of India, the most consequential apex court in the world, guardian of the aspirations of the largest democracy over 1.4 billion people, has adopted a similar principle in its motto, reminding us that victory is not the trump of might, but inevitable crowning of dharma. It is motto is yato dharmas tato jaya. Where there is a dharma, there is a victory. Truth is the tool which sustains dharma, and the path of dharma is what leads to jaya. The ultimate victory, which is no longer just about winning a case, it is restoration of balance. Dharma is alignment of reality with justice. Then a dispute is the fracture of that alignment. When the truth of one party no longer aligns with the truth of another, a claim is made and it is rejected, is when dispute is born. Now, here the role of courts come. In the journey of the adversarial to problem solving, however, the courts will continue to stand as ultimate guardian of rights and the rule of law. But they can no longer be viewed as the only source of justice. Development of multi-modal dispute resolution system is perhaps the best decision we can take for our progeny and for future. This evolution of justice from litigation to resolution requires a concerted effort from all of us by approaching the understanding of courts as an essential service instead of physical location. Professor Frank Sander, Harvard Law School, way back in 1976 proposed what he called a multi-door courthouse model. Back then, it was viewed as a radical academic proposal, but it has come to a blueprint in 21st century justice, where cases are screened at the initial stage and routed to the most appropriate process, whether mediation, arbitration, neutral evolution by conciliation, or traditional litigation. This ensures that the resolution mechanism fits the specific needs, costs, and desired by the formality of the parties involved, while so ensuring that justice is not delayed. This is the need of our party-driven dispute resolution, where parties retain a great level of control over their own fate. And is enabling this, the courts of the future must not merely be arbiters, but rather they must be the directors of justice, truly getting to the core of dispute and understanding the best approaches to resolve it. Now, coming what may be a role of idea in the future dispute resolution. Alternate dispute resolution is said to be future of dispute resolution. But I truly believe that it is now, IDEA has witnessed a paradigm shift in the 21st century, and wherein the various mode of dispute resolution have become appropriate rather than merely being an alternative. While courts and traditional justice delivery system shoulder the constitutional responsibility of interpretation of the law or application of law and to resolve interpersonal disputes, the ADR process offers parties the flexibility to arrive at solutions which meet their unique requirements, needs, and interests. Lack of rigid procedural shackles, which are usually a limiting factor in litigation, makes the mediation process more accessible to the parties. Unique sense of collaboration in area also allows a party to preserve their relationship, be it familial, business relations, or between neighbors. The mediation process encourages parties to be hard on the problem, not on the person, which helps parties recognize that they can work together to solve the problem at hand rather than seeing each other as the problem. Now, coming to the arbitration, our jurisprudence today recognizes a fundamental truth. When a party chooses the arbitration, they choose finality, and court must respect that choice. Arbitration has become a preferred method for resolving commercial dispute at a global scale. With the increasing use of resolving labor disputes, environmental disputes, and other disputes, the International Chamber of Commerce, ICC, reported a record high total case load value, 354 billion, by the end of 2024, involving parties from 136 jurisdictions. Our Domestic Law Arbitration Act 1996 codifies minimal intervention as a letter of law in Section 5, which contains a powerful non-obstante clause stating unequivocally that notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except so provided in this part. With the recent Constitution Bench judgment, Central Organization for Railway Electrification versus ESI, popularly known as Core 2, India has become one of the first jurisdictions globally to delegitimize unilateral arbitration appointment. The majority judgment reasoned that such clauses violate principle of equality and equal treatment of parties enshrined in Section 18 of the Arbitration Act and cast justifiable doubts on the independence and impartiality of arbitrators. The court held that even though party autonomy is fundamental tenet of arbitration, requirement of fairness and impartiality are also sacrosanct. India is positioning itself as a sophisticated, cost-effective, and neutral alternative and traditional Western hubs of arbitration. With rampant economic growth and increasing inflow of foreign money, India is rapidly overhauling its legislative framework of transition from litigation-heavy culture to a pro-arbitration regime that mirrors global best practices. The Indian judiciary, particularly the Supreme Court, has made it clear and concise shift towards party autonomy, respecting the sanctity of the agreement to arbitrate between the parties, minimal judicial interference, restricting the scope of reappreciating evidence or treating award as subject for appellate review, the separability of clauses even if contract is challenged, the promise to arbitrate remains as sacred and independent, finality of arbitral award ensuring that the end of the matter is indeed the end. Coming to the mediation is currently experiencing its New York Convention movement, though the implementation of the Singapore Convention on Mediation. By providing a uniform legal framework for the cross-border enforcement of mediated settlement agreement, the Convention removed one of the primary historical barriers to the use of mediation in international commerce. The fear that settlement reaches in one jurisdiction would be unenforceable in another. In India, we have introduced a mandatory pre-litigation mediation through 2018 amendment in the Commercial Courts Act 2015. The Supreme Court of India in Partial Automation versus Rakheja Engineering has held this requirement to mediate prior to litigation in a commercial suit is a mandatory requirement, and non-compliance must be met with rejection of the plaintiff. We have codified our Domestic Mediation Act. Although most of the sections are not yet notified, yet a visionary law, its intent is explicitly articulated in the preamble to promote and facilitate mediation, especially institutional mediation for resolution of dispute, enforce mediated settlement agreements, provide for a body for registration of mediators, to encourage community mediation, and to make online mediation as acceptable and cost-effective. The key introductions such as granting mediated settlement the same enforceability as court degree, given them legal force and ensuring parties negotiate seriously. Second, protecting confidentiality of discourse. And third, embracing online mediation collectively create a secure and accessible and modern framework for dispute resolution. With the advent of online dispute resolution, ODR, the technology is great equalizer of the future, increasing access to justice and ensuring that justice reaches those who are located at the remote parts. The greater challenge globally, however, is to ensure that virtual sessions comply with high standards of confidentiality that online dispute resolution mandates. Intermingling to process of arbitration, mediation, arbitration, dispute resolution clauses have also undergone insignificant development with time, with innovative multi-tiered dispute resolution clauses being introduced in contracts by parties in exercise of their autonomy. The practice such as arbitration, mediation, arbitration is the best example of evolution of the dispute in future. The human ingenuity has led to us such innovative ways to resolve dispute. Section 30 of our Indian Arbitration Act provides so. This model truly is a best of both worlds since it offers the procedural certainty of arbitration along with flexibility of mediation, a powerful combination of complex disputes. Now coming to the conciliation, which is not a part of this, but I feel it is one of the proactive mode. The conciliation serves as a proactive bridge between the neutrality of mediation and finality of arbitration. It empowers a neutral third party to go beyond mere facilitation by actively proposing an agreement when a compromise is in sight. Earlier, conciliation was governed by Arbitration Conciliation Act, while under new Mediation Act, the definition mediation includes in conciliation for all intent and purposes, making even more robust. Where a mediation or conciliation fails, the binding arbitration process serves as a trustworthy mechanism to resolve disputes. A pertinent example arose before me recently when a municipal corporation of Greater Mumbai reported 3 days back in a judgment I authored and delivered day before yesterday. The court declined to set aside the arbitral award, affirming the sanctity of the process of the arbitration. In this sad case, the parties has temporarily held the arbitration is in abeyance for explore a potential settlement through conciliation. The conciliation proved to be non-starter. The parties were delegated on binding arbitration process, which ultimately culminated in a definitive award. There is an increasing realization among parties regarding inherent values and compromise and settlement. This shift in mindset acknowledges that litigation is often a zero-sum game, whereas ADR offers a spectrum of resolution. Coming to the technology and the evolution of justice system, the world generally and India specifically is undergoing a digital revolution at an unimagined scale. While technology moves fast, the law must move with principled deliberations. As the whole world builds and adopts digital infrastructure at scale, the legal profession must ensure that technology remain a servant of the values of justice, not their substitute. With the rapid integration of AI into commerce and governance, we are witnessing a fundamental shift is how automation influences our life and law. AI can optimize decision-making and draft complex instruments, but does it retain the capacity of understand justice? Certainly, AI can draft 100 pages merger agreement in seconds, but it can understand the underlying interest of the parties, their positions, their bargaining power. That human element is what truly converts a 100 pages document into a true contract. What is vital role played by legal professionals in this era, which must be recognized by evolving justice system. Chief Justice of India, Justice Suryakant, yesterday shed light on the initiatives being taken by the Supreme Court to adapt to technology advancement. It's a concerted effort by the Supreme Court of India, which judges collectively acknowledge. In our view, justice involves more than just logic. It requires empathy, discretion, and the ability to navigate the gray areas of human conduct. AI can't see the number of witnesses, will never understand, and plight of litigants. To let a machine substantively adjudicate upon the rights of the liabilities to parties, a distant and controversial goal. A recent survey by White and Case an international law firm, underscores this hesitation. While 77% of practitioners were agreeable with the using AI to calculate damages, only 23% agreed AI giving decision on merit. However, the justice system must adopt rather than resist this technology interface. AI can serve as an excellent scriber or calculator, making life easier for judges, advocates, and court staff alike. By acting as human in the loop, the legal professional can delegate routine, repetitive tasks to machine while maintaining the vigilant oversight and empathy that only a human can provide. As I look forward to the future, however, I hope that the global justice system in its push towards technology remains cautioned of the inherent risk of uncritical reliance. While AI can process vast amount of data, it remains inept at the rigorous verification of facts. Even dedicated legal AI lacks the scrutiny required to discern the validity of its sources without human oversight. This leads to what people in tech are calling hallucination. This results in automation bias, where judges or advocates may overall trust computer-generated outputs as objective truth, doubting their own professional institution. Furthermore, we must confront the algorithmic feedback loop, because AI is the reflection of the data it consumes. Any existing social or systematic biases fed into machines are not merely mirrored, they are magnified. Without the human in the loop, the break of this cycle, we risk automating the very injustice we seek to resolve. In conclusion, the future of law and dispute resolution is bright and is rest on good hands. The level of innovation and thought which is being put into dispensation of justice is unfathomable. Lawmaking has become increasingly empathetic and cognizant of ground realities. As we stand at this digital crossroads, we must remember that our progress is not measured by sophistication of our tools, but by our fidelity to the values they serve. The values to access to justice, rule of law, and empathy must guide us into future. Let us not meet future with resistance. Let us instead embrace change, the only true constant. As the ancient Greek philosopher says, that a man cannot step into same river twice, because it is not the same river and he is not the same man. Thank you very much for giving this opportunity to me and share my views on today's topic. Thank you.
Well, a huge round of applause for the Honorable Justice J.K. Maheshwari. Thank you very much, sir, for those insightful words. Truly, the future of law is something that he has encapsulated in his speech. All right, shifting our focus to yet another very insightful, interesting, intriguing session. We are talking about the future of legislating the law. And to join us for this discussion, we have Right Honorable Dan Cardon, who's member of the House of Commons, United Kingdom. We have Senator Adela Sipova, who's a member of the Senate of Czech Republic. We also have Honorable Rachel Brooking, who's a member of the House of Representatives of New Zealand. We have Mr. Mikhail Ahmed Nassam, who is a member of Parliament of Maldives. I would request all of you to please come on to the stage. To moderate this session, I am going to invite my colleague, Senior Editor Uday Pratap Singh, on the stage.
Welcome back to those of you still with us at NXT 2026. Hello and welcome to those joining us now as we continue these special panels. And this is also part of our special segment, Next in Law. And it is very fitting that while we talk about Next in Law with legislators, we have a member of the judiciary as well with us, a senior judge of the Supreme Court of India. Let's have a loud round of applause. This is a true executive legislature relationship happening right here. Let me begin by asking you, Dan Carden, if I can, on what the relationship in the United Kingdom is of the executive and the judiciary.
It's a very good question because our history stretches back many hundreds of years and we have an uncodified and unwritten constitution and things have changed over time. But we now have a Supreme Court that's only a couple of decades old. Our Supreme Court used to be inside the legislature in the House of Lords. So we have evolved and modernised in recent years. But I suppose the important thing about British democracy is common law. So much of our law comes about because of rulings that take place within the court system. So you have a sovereign parliament and you have common law.
Let me, in fact, take that to you as well, Adela, on you know, the situation in your country, of course. What is the relationship there in the Czech Republic of executive, of judiciary, the relationship that is shared by them and the balance that the two offer each other?
Thank you for inviting me here. I'm very glad for that. Thank you for the question. Yes, Czech Republic is maybe some of them you don't know where it is. It's in middle Europe, and it's a small country which is a part of European Union, very proud part of European Union, and that's very crucial for us. And for your question, I would like to ask that the constitutional system in Czech Republic is quite stable. We have the judicial system is stable. It's very, very independent, and in charters we are very high of that. I am, as a professional, I am an attorney at law, so I really am proud for our judicial system. Maybe I would like to ask, talk about you know, the topic is about future. And I think I'm very glad that there are so many young people here, because if we talk about future, then we talk about their about decisions that will influence their lives. So thank you for that. I have seen so many young people here. Thank you.
Yes. Rachel Brooking, coming to you next. If we talk about New Zealand, tell us a bit about the relationship there and the system, of course, which allows the executive and judiciary you know, to balance out each other. What is the relationship between the two entities? As they say, these are the pillars of any democracy, and New Zealand is one too.
New Zealand is indeed a democracy, and we have followed much of what Britain gave us in terms of that separation of powers is very important, but also, like Britain, New Zealand has no written constitution. Unlike Britain, it does have a Treaty of Waitangi, which was an agreement made in 1840 by the Māori chiefs in New Zealand and the British Crown in Queen Victoria's name. So that is an important difference, an important part of our constitutional arrangements. And we're also very clear on that separation of powers between all three, being the courts, the legislature and the executive. So we talk a lot about that separation between the executive and the legislature, as well as the difference with the courts. So we are careful as politicians not to impugn any decisions made by courts and to respect those. But an unusual feature in New Zealand is that we only have one House of Representatives. So we have no upper house and we have no written constitution, so we have no constitutional court. And we can change laws in New Zealand very quickly. So how that is relevant is that the court might make a decision that the government, the executive, does not like. So the government will get the Parliament to make a law that effectively overturns that court decision. And that can happen quite a lot in New Zealand, and it can happen in a day, which is quite unusual.
Absolutely. Meghwal, coming to you, given the fact that you come from the Maldives, I'm sure you must be having some of the most prettiest court locations, of course, in the world. But, tell us about the system, of course, there and the relationship that executive and judiciary share in your country.
Thank you for having me on the panel. Given that Maldives is a very young democracy, we only had true separation of powers in 2008 with our new constitution. And we have so far had a very difficult relationship, I would say, between the executive and the judiciary, with judges being impeached depending on who's in government. We saw that in the recent months too. However, I think that as time goes by and as our democracy matures, that the strength of our institutions will come into being.
How do we also ensure this, the Member of Parliament from the Czech Republic said, of course, that the youth is here in big numbers, and how do we ensure for the future, Dan Carden, if I come to you, that this respect for the judiciary continues amongst the young as well? How is it happening in the UK?
It's a good question. I think there's many challenges that we face in our politics in terms of how we rebuild a new social contract between politics, which includes all the institutions of government and judiciary, and the next generation. And I used my opportunity to speak to talk about the importance of politics in the transformation that we're now living through. And you often hear at events like this that borders no longer matter, sovereignty no longer matters, technology is global, and therefore states and nations are less important. And I fundamentally couldn't disagree more with that. I think as this transformation takes place, and actually the politics of the last decade and longer has shown us that many multilateral institutions have been losing the confidence of the public. Publics are turning to their states and their governments more to demand more action and more sovereignty over their borders. And therefore, we mustn't think that because so much happens globally and internationally, that states no longer matter. And I think the next generation will be demanding even more of their politicians, not to be caught up in multilateral institutions and demands of quangos, and we call them quangos, sort of semi-governmental autonomy. They want democracy. They want to be able to demand things of their politicians, and they want their politicians to be able to deliver, and that's sovereignty.
We of course heard from the Honourable Law Minister of India just earlier this afternoon, and here also in a segment as part of NXT Law, spoke about how India has modernized our laws very recently. And, we've enacted a new code as part of the Bharatiya Nyaya Sahita, as it's been called in India, the BNS. Earlier it was the Indian Penal Code, the IPC. Now it's become the BNS, and this was sort of shedding the colonial, era laws of the past and upgrading them to make them more relevant to the India of today. At the Senate in the Czech Republic, how recently have you upgraded your laws? Is there a need for overhaul of laws, do you believe, over time?
I'm not sure if I understand the question, but as I said, Czech Republic is a part of European Union, and European Union is based on values on the same values for all the countries, and these values are human rights, supporting democracies, the rule of law, equality, and also supporting the civil society. So these are the topics which we in our parliament are focused on so as our colleagues from European Union. And I must say that I think that we as politicians in Czech Republic, as I see it, we sometimes have a problem that we are somewhere on the top and we don't know what people are solving in their homes. We don't know which problems they have. So there is a lack of trust in us politicians. So I think that in our policies we have to cooperate with people. And as maybe I can remind you, Václav Havel, who received, that was our former president, he was persecuted by communists during the communist time. He was a leader of our Velvet Revolution. And this president, our beloved president, who's unfortunately not with us, he trusted in people, and he said that democracies are as strong as we communicate with people and with the civil society. So this is, for me, his model is for me, he made me some guidelines how should our parliament work on legislation in the future, how we should help supporting and developing human rights for people and help them live how they want to be much more happy.
Also, after joining the EU, how much has that influenced lawmaking in Czech Republic?
Yes, it influenced very much, and we are not against each other. We cooperate with European Union very, very, often and every day. I am a member of the Committee for European Affairs. So, me as a senator, I am in a very intensive contact with the European Commission, and I must say that for us, for Czech Republic, the membership in European Union is very good, because we can find how our partners in European Union solve problems that we sometimes have. I think all of the countries have solved the same problems, and these problems are housing, services, these problems are jobs, as we solve it here at this conference, AI, of course, and sometimes also the losing of the trust to these democratic institutions. So these are things we are solving in Senate in cooperation with European Union.
How important is this, Rachel, to keep modernizing laws, our legislation, overhauling them from time to time? Of course, AI is something that the Honorable Representative referred to. These are new things that are coming about, which is why obviously we need to have safeguards for them as well. So how important is this constant overhauling and modernization of our legislations from time to time?
So in New Zealand...
And what about New Zealand? Yeah. How recently did you do that?
So in New Zealand, because we have this very fast lawmaking process, it means that we can modernise laws quite quickly, and we have a well-digitalised system of all of those laws as well. In terms of two comments I wanted to make in relation to the other questions as well, is in terms of, I agree with what everyone has said about the importance of politicians and being respectful of the courts and not getting involved. That's one important thing, but also how the courts communicate, because of course most people aren't out there thinking, most people, and it might be different in India, but in New Zealand most people would not know who the judges were. And so how judges communicate themselves is important. And we have a chief judge of our district court in New Zealand, so the lower court in the hierarchy, and he is very clear in what he is calling te ao marama, which is looking to the light, about simplifying court processes so that those involved understand what is happening. So we don't use lots of fancy Latin terms, which I'm a former lawyer and have been guilty of that you use simple language and you have community people in the courtroom as well. So I think that's another important thing to be doing in terms of modernising how we think about the law. It's how people interact with it is very important, as well as how much there is of it and how we go about writing it. But in terms of the AI issue, my observation is that it's very important that politicians are making the decisions on policy. And that is what politicians are there to do. We're there to argue the pros and cons of a different policy. So should we have a speed limit of 50 kilometres an hour or 100 kilometres an hour? Let's argue about the lives that will be saved. That is a job for politicians to do. The actual drafting of the law and the searching of the law, that is a different issue. And how we scrutinise the making of the law, I think there is a role for both human, and I'm sure there are many efficiencies that can come with AI as well.
That's an interesting point that you made. Mikhail, taking that to you as well about this, constant overhaul of our laws. And, she raised a wider point, the Honourable Representative from New Zealand, of who should have the final say in certain matters. Should it be the judiciary? Should it be the legislature? What is your take on that, on specific matters of policy? Should the judiciary have the final say, or should the legislature have the final say? And also, how recently in the Maldives have you overhauled your laws, your legislations, etc.?
I think that when it comes to legislation, well, belonging to the legislature myself, I think my opinion would be quite biased. However, since, I always...
Saying it in front of the judiciary.
I always advocate that when it comes to who should be implementing the law and who should be making the law, it should come from the people and from elected representatives. And so my opinion is quite biased. However, I also believe that there are certain constitutional matters that should be left to the judiciary, and as is the case in the Maldives. And in 2028, coming back to your question, in 2028, 45% of our electorate will be young people. So we are realigning the People's Majlis, and we are going fully digital. And we have also recently introduced an e-petition system. And so I think we are now harmonizing the ways of the Majlis to align with the needs of the young people.
It's quite interesting that you say it's a People's Majlis. So is that another re-emphasizing of the fact that the people should have the final say?
Absolutely.
Dan, coming to you now on the point, of course, of arbitration versus litigation. It's a very legal sort of question, but we have seen this push in India at more arbitration over pure litigation, because there's a lot of pendency of matters in India. Of course, the size is there, and the judges' strength, of course, all that is being overhauled, and efforts are being made, and we have seen, of course, record number of cases come down in recent times over here. What is the kind of pendency numbers in the UK? How fast are cases disposed there? And is there an emphasis on arbitration over litigation there too?
I wouldn't be qualified to answer that question, but in the end, the courts operate on the laws that the Parliament passes. And I think when it comes to technology and AI and the challenges that we face as politicians on behalf of the public, in the UK, unlike New Zealand, where you are, Rachel, law feels like a very slow. It takes a long time to pass legislation through the House of Commons, through the House of Lords, through government. And so I think I would be willing, I wouldn't be able to say exactly how it would look, but I would be willing to look at how we speed up the passing of legislation to keep pace with the technological change that we're all living through. And I think Britain needs to do much more to get laws up to date and protecting the public when it comes to this transformational change.
That's a good point, and in fact, we would vouch for it as well. India has signed a free trade agreement with New Zealand. We have signed one with the UK. We have signed one with the EU. We hope for one with the Maldives too. But it takes its time, because it has to be ratified, and only then does it get implemented. So these things should hopefully move faster. All right, we're almost out of time, so I'm going to quickly end by going across the panel and getting one last thought from you, or one big trend that you see coming in the future of legislating the laws. I'll begin with you.
Maybe I will say what I said before, but I think that we should cooperate with people. We should cooperate with civil society, with non-profit organization. We should focus also on minorities because our democracy is as strong as we take care of these most weak people in our society. So this is a challenge, I think, at this time when we face a lot of disinformation and populism in politics, especially on social media. I don't know if you have it in India, but in Europe we have a lot of hate speech and disinformations. So these are challenges, and we have to be with people, as I said. As Václav Havel said that he believed in people and they loved him. We have to cooperate with them.
Yeah, so going back to my point about policy being decision making and that politicians need to be talking about that and communicating, I think there is a lot of opportunity to do better communication with community, with the voters, with the people, using tools such as citizens' assemblies, but I'm sure there will be some opportunities with new technology in that as well.
I think in the future, I think the onus is on increasing accessibility a lot. I think it started off with COVID, and now we're expanding on that. And with that, I think a lot of our parliaments are now more accessible, and we'll be working on that even in the future.
Thank you. I think the 4 nations represented here.
And 5 with me too.
But
I'm not a
with you.
representative, yes, go ahead.
Although India is perhaps ahead of us 4, I think we don't have the United States here, we don't have China here. We have to be conscious that we are renting a lot of what AI is doing from the United States and from China, and we have to start building it and owning it and controlling it ourselves, or at least having alliances and competition in that, because this is like the Industrial Revolution. You have to create and invent and own the fundamental tools of automation, of AI,